meeting of the Town of Holden Beach Board of Adjustments regular meeting. Today is February the 17th, 2025, and it is 3 o'clock. So with that, we'll call it to order. May we have the roll call, please, Megan?
Ann Arnold.
Here.
Mary Lou Lauren.
Here.
Richard Griffin. Bill Caldwell.
I'm here.
David Yarshevsky.
Here.
Rick McIntyre.
Here.
Richard Roberts.
Here.
Okay, we next will approve the minutes or disapprove. Do I have any comments on the minutes from the November 21st meeting of the Board of Adjustments?
Move to approve.
Second?
Second.
The motion has been made and seconded to approve the minutes of the November 21st, 2024 meeting of the Holden Beach Board of Adjustments. So we declare it approved. Today we're going to hear case number 01-25. There will be a hearing that we will let Tim explain why we're here, Mr. Evans. But before we start that, we have some business that I think we need to attend to. Does anyone have a conflict of interest in this case? I do not. Bill?
No.
Mary Lou?
No.
David Yarshevsky?
No.
You have no conflict of interest?
No, ma'am. I'm not voting in. Not gonna have a conflict of interest, is my case.
Well, typically, if a board member is present and they have a conflict of interest, they have to leave the room. So if I have a motion to allow him to remain, I will listen to that for discussion.
I would think that since he's not serving as a member of the active board this morning, that he's basically not on the board for a day and is a party in participation. So I think he has to stay. I have no conflict.
Do I hear a motion to that effect? You make
So
that
moved.
motion. Second?
Second.
All in favor? You can stay. Has any board member had any ex parte communication or spoken to any of the neighbors, et cetera, with the parties in this case?
No.
No.
To grant a variance, which we have coming before us today, we have to have a 4/5 vote for in favor of, if we grant it, making sure that everybody understands that. Would all the witnesses or parties in this case come to the front of the room, please, to be sworn in? Do we have a Bible? I'll do better. I'm doing better. Put your hand on the Bible, please. And you'll all swear at the same time. Raise your right hand. Do you swear that the evidence you shall give to the board in this action be the truth, the whole truth, and nothing but the truth, so help you God? We will now hear the evidence. Mr. Evans.
Well, I think there's, I don't know if it's real evidence, but it is, it is the case. We all of, not this previous year, but last year, the year before, we sent the property owner a notice of violation. We took notice on a routine inspection on the street that there had been a fence installed without a zoning permit and without a building permit. And we notified him that the fence that he had erected was in violation of the town's rules and regulations. Subsequently entered into communications with him that ended up with him letting us know that he was going to apply for a variance. So that's the crux of it is that the fence in question is actually in violation of the town's rules. You have a list of the rules that he's in violation of. Two main rules that he's in violation of is he's in violation of the right-of-way rule, which is a regulatory rule, not a rule as it pertains to the zoning, which there is no variance from a regulatory rule. And he's also in violation of the zoning rule. 157.080, right, yes. Which is fences. So that's the facts.
Do you want to explain to the board the facts regarding the fence?
Yeah, well, if you look at, did y'all get my notes? If you look at 157.080, which is actually in your exhibits, you will see where it actually establishes that a fence in that section cannot be within 15 feet of the street. Well, you see the street right-of-way, as it is marked on the survey, shows that he's not only within, he's actually within 7.5 feet of the street. He's also in violation of another portion of that section, which is, well, which is actually 95.05, that says you can't be within 10 feet of the right-of-way. And he's actually within 3.5 feet with anything that also includes the fence that's not like shrubbery and that kind of stuff. So that's the crux of it. The other part of it is that that's his front yard, and a fence is not allowed to be more than 4 feet tall in the front yard of a dwelling or a location in a dwelling. They're allowed to be 6 feet on the side and the rear. They have to be 4 feet in front. Those are the violations. The fence was also erected without a zoning permit, and of course, we can't issue a zoning permit when you have a violation of the regulatory rule with a fence in the right-of-way. So we couldn't give you permission to put it there even if we could approve it. Can you, Maggie, can you switch to that next slide?
Yeah. This one?
Yeah, I think that'll work. And can you kind of blow that up? It's the last one. If you look at that, you can actually tell, yeah, it's at the top.
I don't see it on this
Plus, that
Straight- Straight down from where you were.
Yeah.
up at the top is plus or minus.
121.
In order for this fence to have been legal, you would have to establish that where the street is actually not the street, because the rules and regulations say that a house has to front the street. And there is not but one street there. So the front of the house is that which faces the street. So even if the fence was not in the right-of-way, even if the fence was not in violation of 157, in order to have the fence there with it to be 6 feet tall, it would actually you would have to determine that that's not a street. Now, the problem is that it's already established as a street because it's on our POW bill now. We collect money from the state of North Carolina, and the right-of-way rules actually extend out to where the right-of-way stops. We could take the road all the way out. We could clear the right-of-way up, and we could have a walkway out there. We could have a pocket park, anything like we have in the pavilion. And so at this time, that fence would be in that right-of-way. And you know, I don't know how you get around that, but that's the facts, is that fence is too tall to be in the front yard. It doesn't meet the front yard requirements. It's actually sitting in the town's right-of-way, and it violates 2 sections of the ordinance. So that's the facts.
Anybody on Mr. Yarosevsky's side want to ask any questions of Mr. Evans at this time?
Mr. Evans, I have a question.
Yeah, this is the question.
This is,
We're not asking for your presentation yet. Okay. Yes, thank you.
Thank you very much. For the record, my name is Colin Tarrant, the law firm of Block, Crouch, and Keeter in Wilmington. I'm here with Mr. Yarashevsky, as you
I'm
know.
sorry, I didn't get your name.
My name is Colin Tarrant, Tarrant. I'm an attorney with the law firm of Block, Crouch, and Keeter in Wilmington. I'm here with my client, Mr. Yarashevsky, as well as my associate, Jackie Kajigal. As we stated, we're here on two, and I just for the record do want to clear this up. We do have two requests here this afternoon. The first would be an appeal, and we noticed an appeal of the notices of violations that were received by Mr. Yarashevsky as to his property at 121 Seaside Drive. And in the alternative, to the extent that those appeals are unsuccessful, we have requested a variance hearing. We have noticed and applied for both of those hearings, and we are here today on both of those matters. So to the extent that this board hears the appeal and denies our appeal, we would then move on to the variance, other than the height requirement, which is subject to only the variance because it was not subject to the appeal. So I'm not trying to confuse everyone. I really want to just try to get everyone on the same page so that we can move forward kind of in a linear fashion. Right now, as I understand it, we're dealing with the appeal itself. So I do want to focus on the notices of violation that Mr. Yarashevsky received and what those notices of violation included. So the violations that he was informed about, that he was provided an actual ordinance section and was able to analyze and determine the best way forward. Because that is an important distinction as to how we've wound up getting to this point. This is not something that's just accrued in the last month or two. This is something that's gone on for a very long time. So just from a procedural standpoint, I want to make sure we're all on the same page. I understand that Mr. Evans has put forward evidence on behalf of the town as to the appeal, and I believe as to the variance, and that now it's our opportunity to ask him any questions.
Ask questions of Mr. Evans, please.
Mr. Evans, this matter has been going on for quite some time. The notice of appeal was originally sent to the town back in April of 2024. Since that time, when the notice of appeal was satisfactorily sent to the town and accepted, have you had any conversations with any members of this board about this matter? Okay. And Mr. Evans, the first notice of violation that was sent to Mr. Yarashevsky was sent to him back in October of 2023, is that correct?
Yes, sir.
Can you tell us what violations were included on that NOV?
The 157.08, it was included the code and the code descriptor, and it talked about fences, 157.080. Would you like me to read it?
You can paraphrase.
Well, it basically says that the fence is in the front yard, is too tall for the front yard, and that it is in violation of 157.080 and 157.081.
And following the notice of violation to Mr. Yarashevsky in October, beginning of October of 2023, I think in your presentation of evidence, you said that there were certain communications that then began between yourself and/or Ms. Piggott, I believe, and Mr. Yarashevsky. Do you recall those communications?
Yeah, the first conversation we had, he was very receptive, he was very cordial. We got the impression that he was going to try to remedy the situation. And I think we had some emails, and I think there was a meeting was supposed to take place.
Now, did Mr. Yarashevsky at that time indicate to you that he had put the fence in himself or that he had hired someone to do it?
He indicated to me that he had hired an outside contractor to install the fence.
Now, was Mr. Yarashevsky apologetic? Did he indicate that this was a mistake, that he meant to do it? What was your impression from those communications?
The first conversations that I had with him, if I remember correctly, I thought were very productive. I don't recall any kind of an issue with the first conversation at all.
Now, there was a meeting that was scheduled for the 30th of October, so this would have been about 2 weeks or so after the violation was presented to him. And I don't think that anyone showed up from the town to that meeting. Is that correct?
I believe, yeah, I think that Janet was out sick, but I do believe that we had communication saying that there would not be anyone there.
Do you know when that communication was sent to him? Like how far in advance?
That's been a while back. Okay, we're gonna need to swear Janet in. Janet's gonna
Okay,
need to be
she
sworn
says
in.
hers. If I can find my paper. Do you swear that the evidence you shall give to the board on this action shall be the truth, whole truth, and nothing but the truth, so help you God? Thank you.
I apologize.
It's okay.
Yeah, she can answer the question.
The meeting was scheduled for Monday, and I became sick over the weekend, and at that time I didn't have access to my work email, so I wasn't able to reach out to let him know that I was not going to be able to make it. But I believe he came into the office and spoke with him.
Okay, and I guess, Tim, this will be directed to you. I mean, and you're aware of the fact that Mr. Yarashevsky lives primarily out of town, correct?
Yes.
Okay. During your communications with Mr. Yarashevsky, it was indicated to him that he was to apply for a zoning permit. Is that correct?
The first conversation that I had with him, I explained to him, now you got to remember, this work was done without a permit. We didn't have a site plan. We didn't know exactly, we knew that the fence was too tall for the front yard, and we knew that was a violation. And so that was the only thing we knew. And yes, we told him the remedy for putting a fence in without a permit is that you've got to get a zoning application turned into the town hall so that we can review it for compliance. And then if we have to turn it down, then you can qualify to get a variance. Me and him had an extensive conversation about that.
And during those conversations, did you have any discussion as to the location of the fence and his understanding of what he believed to be the yard?
Yeah, he explained to me that he felt like that his front yard was not the one that had fronted the street. And I explained to him that our rules indicated that that is the front of the house.
And just for the record, and what are those rules, just to make it clear for
The
everyone?
ordinance says that the front of the house is that which affronts the street. I think y'all have a copy of the ordinance.
And it's just for the record,
Yeah.
just making clear, so I apologize if I'm not trying to
Yeah.
make you state things that everyone knows. Now, Mr. Yarashevsky indicated to you that he would pursue the zoning permit, but my understanding is that there was a requirement that a survey be done, and I think, and correct me if I'm wrong, Mr. Evans, there were communications between you and Mr. Yarashevsky in the subsequent weeks regarding some delays and some issues getting that survey?
Yeah, I think that everybody was having a hard time getting surveys at that time. So yeah, we did have a conversation about that. And we needed the survey in order to give it a proper review.
So in the weeks and what turned into actually, months after the initial NOV, you were in communication pretty regularly with Mr. Yarashevsky, and you were kept in the loop, so to speak, about his actions and what he was doing to try to obtain the survey and apply for the zoning permit. Is that correct?
Yeah, I would like to, it was a while back, but I do recall, because I had this conversation, that I told him that typically he was concerned about the fines and that kind of stuff, that as long as you're taking action, we don't take action. And I made that clear, I make that clear to everyone, that as long as you're doing something to try to comply or to get us to that point, we don't take action. And so that was an important conversation I thought that me and him had. So.
And then I believe, Mr. Evans, you and I even had a conversation about that. And, you know, probably we got involved in about December, and I think one of the first conversations I had once I got involved was with you, and you communicated that as well to us.
Yeah.
And we also indicated we were working hard to try to get that survey and get that application into. And this is probably more of a question for Ms. Piggott, just because I believe that some of this communication was between herself and Mr. Yarashevsky. But in November, so during this same time period, there's an email from Mr. Yarashevsky to you where he asks specifically about the violation and specifically about whether or not there were any other violations that he needed to be aware of at that time. Do you recall that email or that communication? And that's okay. I mean, I'm not putting you on the spot. If you don't remember, you don't remember. Okay. So it's safe to say you don't remember your response. Okay. All right. So there's a time period around, I would say, December and January of 2024. Mr. Evans, you and I had that conversation. Do you recall during that conversation indicating to me that there would be some delay on the town's actions moving forward due to the fact that there was an issue with a recent resignation of the town attorney and the search for the new town attorney and needing to get someone in place? And do you recall when Ms. Moore was retained or hired? And if you don't, it's okay.
The days seem like years around here. Well, I don't.
If I said it was somewhere in the end of February, beginning of March of '24, would that?
Accurate.
So Mr. Yarashevsky did eventually submit a zoning application, and he did include a survey and provide that site plan to you, correct?
Yes, sir.
And that zoning application was submitted back, I believe, in March of '24,
Yes, that's correct.
and I'm using approximate dates. There was a second NOV then that was issued and sent to Mr. Yarashevsky following the zoning application. Mr. Evans, you've touched on it a little bit, but in this second application, what were the actual violations that were included in that?
I don't have that for me. I know that if by then we'd probably had a chance to look at maybe the application, and there may have been some, were there any additional? Yeah. Realize that it's actually in the right of way, so we may have included that.
So in that second NOV, I believe that was when we first were notified of the violation for the roadway.
Yes, sir. Yeah, I don't, at any point, we would not have known exactly where that fence was in relationship to the right of way until we got a survey, you know what I mean, and had a chance to review it.
So if you went out there and you looked at the location of the fence as it, in relationship to the existing right-of-way, you wouldn't know that it was encroaching into the right-of-way without the survey.
If we looked at any structure on any property without a survey, we would have no idea whether, including this one, whether or not what's on site is encroaching.
Well,
That's why the town requires for any development, the town requires a survey to scale before you can start work.
well, I think you would admit that this location of Mr. Yarashevsky's property is a little different from most in its proximity to the right-of-way in front of his home, correct?
If you're asking if it's peculiar to the end of the streets in this town, it is not. There's actually one on the other side that's exactly like it, and there's several others where the street actually stops, the paving stops, but the right-of-way continues to go. And I hate to say this, but as the planning director for the last 15 years, I'm pretty much aware of how far all of them go because that's my job. So I knew there was a right-of-way that went through there. Where the right-of-way line is what I would be guessing. So we actually have to have surveys. But I do know, we did know when we went out there that the right-of-way, it was possible that it was close to the right-of-way, but we couldn't tell if it was in the right-of-way. We didn't have no idea because of the width of it down there. And as a lot of people who are in the town are aware of, a lot of our, and this is something for the board to consider, a lot of our roads, one of the reasons we have to have surveys is because they're not in the center of the right-of-way. For whatever reason, a hazard, a storm event or something, and they may end up moving. They could be left or right, which is another reason why we have to have surveys. And another reason why people should get them before they do work.
So the second notice violation that indicated the encroachment into the roadway, did that include the regulatory provisions that you've cited in your presentation to the board as to?
We put it, it's actually in the, we actually gave a copy of the ordinance, and it's actually in there with the exhibits. It's actually right in front of me, 9505, it's Exhibit 6.
And I understand that it was provided with the agenda packet for today's meeting, but do you recall whether or not that was cited in the notice of violation?
I think it was in the second one.
Okay. So when you're talking about a regulatory provision, are you talking about the ordinance itself, or are you talking about state statute or some other administrative
Okay.
code?
I'm talking about the regulatory rules for the town. There's regulatory rules under municipal government, and then there's actually zoning rules and guidelines. Our zoning section starts at the 150, 154 section. That's the zoning. Our plan, we all know that you can't get a variance from a regulatory rule. You can, however, from the zoning.
All right. And in the second notice of violation, does that mention anywhere anything about the materials that were used for the
I think
fence?
we did, include that because now we know where the fence is at, and we had some idea of how the fence was constructed, and so I think we did include that. We did add that to the second notice.
Did you include the section of the ordinance in which that rule was cited from in the notice of violation?
Well, it actually would fall under the building code, and it would also fall under the NFIP ordinance, which is, I think this is it right here. Yeah, so, but it would be under the 154 of the town's ordinances. It looks like we put the flood damage prevention, we put the definitions on the first page because it references the free of obstruction requirements under the NFIP and FEMA. So we actually gave in this presentation the building code requirements with the definition, which takes you to 322.2 in the building code, which then references not only just that through table 302.1.2, which references the NFIP of the local jurisdiction, and then the local jurisdiction has an NFIP, which is the town of Holden Beach, which references the FEMA technical bulletin for construction of fences.
So for purposes of my questioning here, and I'm not doubting that the town has put their fingers on the authority that they are basing the violation on at this point and has provided it to the board in preparation for this meeting. What I am focusing on is the second notice of violation and whether or not that information was included in the violation that Mr. Yarashevsky received.
Yes. To
It
my
was.
knowledge, it was, yeah.
Do you have a copy of the notice of violation in front of you?
We don't think that, but we did that. It appears it was not referenced.
Mr.
Not
Evans,
referenced.
and just a follow-up there, I mean, I understand that the town's position today is that Mr. Yarashevsky's fence is in violation of that provision of the ordinance, but how is Mr. Yarashevsky supposed to know that he's in violation if he doesn't receive a notice that indicates that?
Was it, if we're, well, to start off with, Mr. Yurashevsky is supposed to be knowledgeable in the state statutes when he starts doing work. You got to remember what I said. The town's not going to send a notice of violation for a building code violation under general statutes. I just told you 322.1 comes out the North Carolina Residential Building Code. We ain't gotten that far yet because he hadn't qualified for a building permit. Had he have qualified for a building permit, he would have been turned down again because he's in violation of the North Carolina Building Code and the town's NFIP. So my thing is that while it may not be in the notice of violation, it is still statutory, that's statutory rule. So it didn't show up in the notice of violation, but I can tell you that we hadn't gotten to the point, if we had got a building permit, we would have then been able to quote him this, but he's still in violation of this. He's going to be in violation of this, of that section after today. Because he's not got to the building permit stage. You got to get a variance from here before I can issue a building permit. So he ain't got there yet. But it's not in the notice, if that's what you're asking.
That is all I'm asking. I appreciate that and for your candor on that.
Hold on a second. Let me rephrase. It was in the first one. He was saying. It's actually on the comments section. Fences are not to exceed more than 4 feet. Fences are permitted through our department. Please submit a zoning application survey showing the fence along with the fence details, height, distance. If you do not have an existing survey showing your house and property lines of your home and a survey to be submitted with your zoning application, the fence is more than 15 feet. So where's the other section? Oh, yeah, it references the materials used. But that's not, it was not in the notice. It's not in the notice. The fence requirements for construction was not in the notice.
Thank you, sir. As I stated before, the appeals letter was first submitted back in April of 2024. That appeal was properly noticed, but there was a request by Mr. Yurashevsky to follow up with a new appeal letter that was sent in June. The town did receive that. Do you know, Mr. Evans, why it's taking so long for us to have this hearing today?
Well, I can tell you that if you presented it to the town, you didn't present it to the planning board, or to the planning department, you actually had to present it to the Board of Adjustments, so that would be a better question for them. I didn't deny access to a hearing. In other words, I don't
Right
know.
now, I'm asking questions of
But
the
I
witness,
don't
which
know.
is you, and that is a
Well,
perfectly good
I don't-
answer. You
Yeah, but I
don't know.
I don't know.
Is your understanding of the ordinance that an appeal before the Board of Adjustment is to be heard within a reasonable time of its submittal?
I'm aware of that, yeah.
In your opinion, and I understand that you are here on behalf of the planning department, do you believe that this appeal has been heard within a reasonable time of its notification?
I do not.
That's all the questions I have.
Does anybody have a comment? Any board members?
Just clarification, I guess it's, okay.
Please go ahead.
We understand the height situation, we understand the right-of-way situation. I may need just a little clarification. Is this house in a defined flood zone?
Well, oh, yes.
Okay.
It's actually.
I thought it was.
Yeah. But I think it's my opportunity to ask questions.
It is.
Yes.
Excuse me, have you made your presentation?
I have not.
I think that'll have to be deferred until he makes his presentation.
Well, I'm not going to, I don't think that the planning department is interested in making a presentation for the appeal. I mean,
That was my next question.
so,
I'm not aware that we are the board to hear an appeal.
yes, you are.
We
Yes,
are,
yes,
we
you
do
are.
hear appeals,
Yeah.
but our appeals are to allow for variance. That's the result,
No,
either a variance
no.
or,
I'm not sure what the appeal is. I guess you'll have to make it clear, but you will have to make it you will have to listen to his appeal as to the interpretation of the ordinance, is my understanding. Is that correct? Is that what you're, so he's going, and
he hasn't
you,
made that presentation.
well, he will. And what I'm saying is that we have no presentation for the appeal. So,
You have no presentation for the appeal, so you're not prepared for that side.
well, no, yeah. It'll be based off of what they say.
Okay.
We're just,
Okay. I got you. I got you.
we're not, our actual, anything that we'll have to say will be direct information from the ordinance. We will act as your voice for information, if you ask us.
I would like to interject that this is not the first time this has been before this board. This case came up earlier. I don't remember the date. Does anybody remember last year?
It came up in the fall,
It
maybe
came up in the
October.
fall, but there was no representation, so we canceled it. It was scheduled. It was scheduled.
Madam Chair, may I be heard?
I'm sorry?
May I be heard?
Certainly.
There was no notice of hearing that was received by my client or myself for us to appear at any other time other than this. And at all times relevant to the matter, I've been in direct communication with the town via Ms. Moore and/or Mr. Evans, and we would have absolutely appeared. In fact, we've got multiple reams of communications that will indicate our continuous request to be heard at the most earliest time possible. And for whatever reason, and I'm not here to make that determination, but for whatever reason, we were repeatedly told that this board could not be convened, that a quorum could not be met, and that we were not entitled to be heard until such time as that Board of Adjustment could be organized to hear our appeal and/or variance. So at all times, we have been pushing to be before you and have not been able to be here. We would never have missed this here if we knew about it.
Everyone sitting up here was not on the board at last year, I don't believe. You were not.
I don't remember the meeting.
I know, you were not. You were, okay. We had a packet.
Well,
We have a packet. I have a packet in my possession.
We would like to reserve the right to take a look. It is our recollection that we were contacted that the property owner would not be here because he had another, if it was my understanding, that he couldn't make it. Now, I could be wrong, I could be,
We had it
yeah.
scheduled. And
We're
all the
looking for it.
notices had been sent
We're
out.
looking, but-
May I swear you in, Megan?
Sure.
Please.
Yeah.
Do you swear that the evidence you shall give to the board on this action shall be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. I simply want to know, Megan, did you prepare for a hearing on this case in the fall of '24?
Yes, and we were gonna meet, but I wanna say Mr. Griffin could not make it, and he made up the quorum, so we canceled.
So we did not have a quorum.
We did not.
Was there any reason that I would say Mr. Sharpsky's side could not be here?
They were gonna be here, yes.
They were going to be here. Okay, so it was our fault. Okay. You understand this is a small town, and we have a difficulty sometimes with sickness and whatever for getting a quorum together, but I apologize for the time it's taken as the chairperson of this board. So, anybody want to ask any other questions of Mr. Evans? Yes. Time for Mr. Evans, okay. We'll hear from you. Make sure that I have his name correct. Carrington, Mr. Carrington. Is that correct? Close
It's
enough?
Mr. Tarrant, Tarrant.
Thank
That's
you.
my last name.
Carrington, okay. Thank
First name is Colin, though, so that's probably where you got the C from, which is fine. And I do have a PowerPoint presentation. So again, this is a little bit of a crossover. I'm going to do my best to try and keep it separate, and I think Mr. Evans has touched on the fact that the appeal and the variance are obviously similar. We've got the notices of violation that have been indicated for appeal, which, just so we have an understanding and everyone is on the same page, the notice of appeal specifically deals with the encroachment into the roadway as well as the materials violations that were alleged to have been pertinent or applicable to this property. The actual height of the fence, which has also been noticed for violation, is not part of the appeal. That has been reserved solely for consideration under a variance request. And then our request for a variance would also include the two notices of violation that are subject to the appeal, which I've already stated, which would be the encroachment and the materials violations, if in fact our appeal is unsuccessful. So again, just to make things more confusing, there is a little bit of an overlap, but not a complete overlap, just the two. So I'm going to try to keep it pretty brief. I've already gone through, I believe, and given somewhat of a timeline, but I do want to call your attention to it again because I do think it's important. And Mr. Yarashevsky bought this property back in June of 2023. When he bought this property, obviously, as we discussed, he's not a full-time resident of the town. He does live in Sampson County, and he does come to and spend quite a bit of time in Holden Beach now that he's purchased the property. And they have dogs, and his wife have dogs, and wanted to fence in their property. And the fence was contracted and built somewhere at the end of August, beginning of September. So I think it was concluded around September 5th of 2023. Is there a way that I can move the PowerPoint, or do I just need to like point?
Do you have copies of those for us?
I do. I'm going to
It would be
get
easier for me rather than breaking my neck looking over my shoulder.
I agree. Let me hand those out.
Thank you.
If I may, hand those up. And if I could ask the board, I would like this entered into the record, if that's okay.
Certainly. That's better, thank you. Do you have a copy? Let it be known that the PowerPoint has been entered into the record in print. Okay, this is much better.
And if I may, just for purposes of the record, also request that the PowerPoint, the digital presentation of the PowerPoint also be entered into the record, Madam Chair, if that's okay with you.
So done.
All right, so we have a timeline for you, just so you can kind of see how things have progressed on behalf of Mr. Yarashevsky and the property. And so, as I stated, he bought the property back in June of 2023. The fence was erected on the property in September. Mr. Yarashevsky didn't do this himself. He hired Infinity Fence and Storage LLC, which is, obviously not located here on the beach, but it is located in Brunswick County. They're a reputable fence installation company. He is not from the area. He, believed that he was hiring a professional who indicated to him that they had installed fencing on the beach before, were familiar with the ordinances, and knew what they were doing. And obviously, Mr. Yaroshevsky had no reason to doubt the veracity of those statements. And when he hired them to do the fence, again, as Mr. Evans has testified, Mr. Yaroshevsky believed, due to the configuration of his lot and the location at the end of the road, along the canal, and at the corner of the marsh, that the area in which his lot is located, what essentially by ordinance is defined as the front yard, was the backyard. And I do not have the fence installers here to question them, but I believe that their own work indicates that they also believe that that fence in area, which is the subject of this hearing today, was essentially the backyard. As Mr. Evans has talked about, if you have the backyard be where that fence is located, you don't have a notice of violation for the height, because 6 feet in height would be required, but you would still have the same notice of violation that we're here for on this appeal, which would be that encroachment and the materials. Mr. Yaroshevsky, as soon as he received the notice of violation, moved quickly to go ahead and get the survey in order and get a zoning application completed. He was at all times communicative with Mr. Evans and with the town, letting them know he was working on it, trying to get them the materials that they needed in order to analyze his property. It wasn't until March when he was able to submit that, and when he submitted it, he immediately got back 2 more notices of violation. So now he's trying to follow the process, and when he does follow the process after he's already been told, and which has been indicated to him via emails with Ms. Piggott, that he did not understand there to be any other violations, that this was the process that he needed to follow, which was to submit the zoning permit application and then work through this issue with the height. So it was news to him when, in March, he got the second notice of violation, which calls into question now whether or not the height issue is the only issue that he's dealing with on the fence. The problem here is that the second violation doesn't include any citation or indication at all that there's an issue with materials. It just doesn't have it in there. And the first violation, which I believe Mr. Evans was referring to, mention materials, also does not really indicate that there's a violation as to materials, and it certainly doesn't provide any section of the ordinance upon which Mr. Yaroshevsky or anyone else who's reading that notice of violation will be able to tell exactly what the violation is. Without knowing what the violation is, how is he supposed to defend himself or go through the process that everyone in this town is entitled to, which is a hearing and a determination as to whether or not he's truly in violation? Now, Mr. Evans has testified during our questioning that regardless of whether or not he received the violation, he's still in violation. And there's some truth to that, if in fact that's the case. But that doesn't take away from the fact that Mr. Yaroshevsky, like every other member of this town, is entitled to a violation that clearly indicates what the ordinance is that he's in violation, and and to an opportunity to be heard and determined whether or not that is in fact the case. That didn't happen here. The due process that Mr. Yaroshevsky is entitled to, which would require a reasonable time frame between the appeal notice and the hearing, it's in the ordinance, 154, I believe, section 154, which indicates that appeals are to be heard within a reasonable time. Now, case law is all over the place. I can hand you guys up case law that says what a reasonable time is, but I can tell you that a reasonable time is usually within a month or two. Anything outside of a month, 30, 60 days, without some sort of real excuse is going to start calling into question whether or not that's a reasonable time. I can tell you that almost a year, probably not reasonable. And here we are. Our argument would be that the notice of violation, to the extent that it even properly indicates what the ordinance is, doesn't and hasn't been provided to Mr. Yaroshevsky the opportunity for him to be heard within the reasonable time frame. We would say that the statute itself or the ordinance itself would require that he be indicated clearly what the violation is and that he be heard within a reasonable time. Our appeal is based just on that. That the process upon which we have taken to get here was not correct. That it should have been done differently. And ultimately, Mr. Yaroshevsky has been prejudiced by that. Because in order to properly defend himself, in order to keep this going, Mr. Yaroshevsky has had to retain my firm. He's had to continually stay on top of the town in order to get himself here today. I can stand here and say that I don't know if we would be having this hearing if it wasn't for our office making sure that we continue to press with the town to make sure that we were placed on your schedule as soon as possible. And that is with an understanding that most people who live in the town may live somewhere else. Many members of the board may travel, they may not be here full time. But a year to us is excessive. And so our appeal is premised upon the failure to follow the requirements and procedures that are set in the ordinance itself and by North Carolina general statutes. Now, again, if we go to specifically the materials, Mr. Evans has provided some documents to the board with the agenda that are from FEMA and that are also part of the National Flood Insurance Program. And those materials that are cited, that are highlighted, would indicate or appear to indicate that the fence in which Mr. Yaroshevsky is constructed would be in violation of their rules. But in the ordinance itself, it's not really clear. It's not really clear where those material issues would fall in. So even if there was a citation to a section of the ordinance, our position would be that it would be questionable that could even be done based upon the language of the ordinance itself. And Mr. Evans, you will be more than welcome to answer or ask any questions of me after we're done with our presentation.
That's our rules of procedure.
Yes, ma'am. He just sounded like he had some objections to our statements, and so he's entitled to question us as he
We're
wants.
not a formal court of law, so you continue, please.
I understand, ma'am, but this is a quasi-judicial hearing, so
I understand that.
whether you like it or not, we do move by the rules of civil
He
procedure.
will have his opportunity to cross-examine you.
He shall. He shall.
But I'm going to call for a procedural here. To start off with, I don't have to cross-examine him. I can cross-examine the property owner.
Okay. Very good.
Simply put, this wasn't done correctly. And Mr. Evans can stand here today, he can sit there today, and he can tell us that we're in violation. And he can tell us that regardless of what this board decides today, we're in violation. But I can tell you that regardless of what this board decides today, that the process wasn't done correctly. And if the process wasn't done correctly, that's going to have to be defended. And that ultimately, the only one who suffers from the process not being done correctly is my client. That's it. Not you guys, not the town staff, Mr. Yaroshevsky. And it's unfortunate. It's unfortunate that we're here for those reasons. Now again, our position is that Section 9505 that deals with the street rights-of-way talks about the area of the rights-of-way beyond 10 feet of the pavement or the roadbed. Well, the area in front of Mr. Yaroshevsky's property outside of the driveway is not paved. There is no roadbed. That area, even if there is a interpretation that the unpaved right-of-way would still apply, Section 95.05C states very clearly that in those areas of the roadway you can put landscaping. In those areas of the roadway, it shall be kept clear of man-made structures, except fences. There is an exception for fences in those areas. Our position is that because there is no pavement, there is no roadbed. The only thing there is a marking on the fence, marking on a map that indicates the right-of-way. That when you interpret this, you have to look towards the exception for fences, because even if it was there, the rule itself makes an exception for man-made structures. The only man-made structure that it makes exception for would be fences. Landscaping is permitted, as would fences be. There's nothing in front of Mr. Yarashevsky's house except for a grove of trees. That's it. The roadway stops at the driveway. From the driveway forward, pavement stops where the road is, and it's a grove of trees before you get to the marsh. Our belief, and we're asking you as a board on appeal, is to interpret that potential violation as meeting the exception for fences. Because there is no pavement and there is no roadway. There is no cars traversing through. There is no impediment that this fence would provide to anyone attempting to utilize the right-of-way, unless they wanted to drive right into a grove of trees and then essentially into a marsh. They would have no reason to traverse that. The spirit of that ordinance section is to keep the roadway clear so that it can be utilized and used by the town. No one is utilizing this. No one is using it. And even if they were, there is more than 40 feet of right-of-way, which is shown on the survey that's been provided, to indicate that the fence in Mr. Yarashevsky's property and its encroachment into the right-of-way is not causing any problems to the spirit of the ordinance. So again, calling your attention back to the materials, which is not even included in the notice of violation, and the roadway encroachment, which we believe Mr. Yarashevsky's fence meets the exception of 95.05 in the ordinance, are subject to our request for an appeal as to the interpretation, because we feel that they're improper for consideration at this time, that the procedure wasn't properly handled, and that the interpretation in which staff has placed upon Mr. Yarashevsky to underline his notice of violation were also incorrect. I'm happy to answer any questions that you have. Mr. Yarashevsky is here as well. My understanding is that Mr. Evans would like to question Mr. Yarashevsky, which he's entitled to do. Other than that, I'm happy to answer any questions the board may have.
Does anyone on the board have a question? We defer to the staff.
I have a question. When I'm looking at this GIS, and I see there's a house almost across the street, where the fence is, on that side of the lot, that would be, that side of the street, that would be in the west. No, Sunrise is in the east, I mean the east side. Is that a buildable lot? Is the lot next to them?
It's underwater.
That's not a buildable lot?
It's marsh. His lot is 100 by 100 in essence, and then the bulkhead is against the marsh.
Not buildable, not buildable.
Right.
Two houses here. This thing's in this right of way. A little bit.
But it's still considered a parcel. It's
Yes.
still another parcel, it's another lot, which shall know.
Yeah, but it's always going, what I'm thinking is if those two aren't buildable lots, I mean, and I know that it's in violation. I understand that. But, you know, they're never gonna be built on. When you go down that street,
But the end,
those two are the last houses that are ever gonna be.
but the fact was presented by Mr. Evans that this could become a part of the town's, economic,
You got a similar situation right next to your house, Mr. Caldwell. That's the end of a right-of-way that does not have a road.
right.
And that is the town's property for the public to use.
Yeah, this is
And
a public
I
property.
understand that, Tim, I just,
It could be
You
used
want-
for a small park or whatever.
well, I
Well-
guess, but it probably never will be built. It'd be a nice place to walk the dogs. Type thing.
Okay.
All right.
All right.
I think that I may be going to do something a little different here. I don't think we have questions about it. I think I would just talk to this and try to work myself back through the information we just had. A year is a long time to do an appeal. I'm not real sure what you're appealing. I do know that staff had communications with the property owner. And during that communication, we told the property owner that if he would take some action, that we would not take it any further. So there was a period in there when we believed that he was working in the best interest of both himself and the town, where that we might could get some mutual cooperation. Now, during that period, we did not have the information that we needed. We simply thought he was in violation of the front yard setbacks. And I don't think that anyone can argue that we thought any differently. And the ordinances for the town require you to get a permit, a zoning permit for this type of work, and you have to get that minimum zoning permit for this type of work so that you don't have this kind of mistake. Now, when the application came along and we got the application, and then this survey was sent sometime later to our attorney, who then transferred it to us. Once we reviewed it, we then realized it has the other issues. Now, typically, when we send out a notice of violation to a property owner for a zoning violation that would then switch over into a building code, we don't know how something is constructed or built, because if it's done properly, then or if it's already done, then there's no way for us to review it to tell whether it's going to be done properly. Now, bringing this fence into compliance is done every day. And I can't recall, it may have been someone else, but I have made numerous suggestions in my career, and anyone who knows me knows that I would have been more than willing to help him to bring this fence into compliance when it came to the NFIP. But I would not have had, I don't think, any authority to reference those codes that we're talking about until he actually applied for a building permit. You got to remember, the town taking an awfully long time to hear their appeal was also brought on by the fact that we didn't have the information yet, because of the number one thing that everybody, I don't know of anywhere in the state of North Carolina or anyone else that can tell me that they believe that they can do this type of work anywhere without at least checking to see if you need to get a permit. Without at least checking to see. Now, I'm not sure what he's asking for appeal. I'm assuming he's asking for appeal for everything that's in front of him. I can't tell because we covered so much. What are we asking for the appeal from? Are we asking for the appeal from the 154 zoning for the fence? Are we asking for an appeal of the 080 or rule, which says that you can't be closer than 10 feet to right of way because that's encroaching 3? Are we asking for an appeal of the fence ordinance that says it can't be within 15 feet of the edge of the street? I'm not sure what we're asking for appeal, but I can tell you all of those things would not have happened had a proper permit application, a zoning application been applied for, and the town had had a chance to review it. And I understand, I don't know how we're supposed to tell him about things that we have no way of knowing until he provides us the information that we have. It shouldn't be on the public for us to go out and have the property surveyed to show that he's actually in violation. If the rules had been followed the way they were written in the book, if he'd have come and got a zoning permit, Jana would have reviewed it, and we could have said, no, you can't put your fence there, and it's going to be too tall because that's the front yard. To argue against the ordinance that that is not the front of that house would be to argue, Mr. Caldwell, that there's a road behind it because of the way the ordinance is written. So I'm not sure what the appeal is. I'm assuming it's for everything. I'm assuming it's for all of it. If you issue him an appeal, it is not a variance. That means that now, if you tell him that all of this is wrong, at what point when he goes to remodel that house, do we know what part's conforming and which part is not conforming? Because now he's reoriented his house. He has a fence that would be too large for anybody else in the front yard. And I'm not even sure the setbacks are going to work out the way they were supposed to originally. So giving him an appeal may create more problems for him in the future than it does now. It seems to me that none of this would have happened had he simply complied. Why could he not cut 2 feet off the fence and move the fence back to the property line once he got a survey that showed he was in the wrong place? He said he didn't know. Well, he's known since the 5th day of March, and that's when we knew. We got it sometime after that. That's when we knew, but he knew before we did because he got this before we did. But he didn't take action like he was in violation. Instead, he was asking for appeals against something that he knew that we couldn't possibly move forward. We don't even know. I don't know what he would ask for an appeal from. Would he have come in here and asked for an appeal for the front yard? Because he didn't know it before that when they asked for that appeal. And if he did, he would have been asking for it prior to us getting this. So yes, this took a long time. It took outside the ordinance, but I'm not sure that we're in violation of the ordinance when we don't have the information that we need to come to the conclusion. It wasn't until the 5th day of March of 2024 that we would have known about all the other violations. We know about the front yard setback. That's obvious evidence. But we didn't know about all this rest of it until then. So if he'd have had his time to appeal under the first rule, then we would have been sitting out there with a fence that was in violation of 9505 because he would have got his appeal prior to us knowing all the facts, in my opinion. But if the board comes to the conclusion that is the front yard, that front yard is actually behind that house, where he thinks it is. If the board comes to the conclusion, the last thing I want to say is he bought this property. When he bought this property, he didn't know where his property lines were, because they don't go in the street, and they certainly don't go where that fence is at. And he said he just purchased it. So how many people buy property and don't know where their property line is on a piece of property that costs that much? That's kind of hard to believe. I guess you could, but it's kind of hard to believe. But I don't think we need to question him. I don't think that they should be given relief or this appeal should go through, because I believe that they had every opportunity to comply, and their contentions were that they wanted to keep that fence.
Any questions? Anybody? Cross? Whatever you want to call it.
If I could just a couple clarifications.
Clarification,
Kind of
please.
got off the rails a little bit there.
Again, we're here on an appeal, 2 issues. And I do want to just make it clear, because there's a question as to what we're exactly asking for. The 2 issues that we're appealing will be the materials. The materials were failed to be included. The notice of violation as to the materials was not included. It was not properly cited. That is what we're appealing. We want to know why we're appealing. Yes.
If we give an appeal for materials, what would that mean to Mr.? I want to ask the question. What does an appeal for materials mean
So
What
what
does
we're
it mean?
asking for is an interpretation.
That's not what we're here for. We don't interpretate. We don't interpret anything. We need the facts.
You do
What
interpret,
want
with all
me-
due respect. I'm sorry, just with all due respect, that is why you're here. You're
No.
here.
No, we look at the facts and we make a decision. And I want to know what fact you are expecting as a result of getting an appeal for the material.
It's very simple. We're here on a violation that my client has not been adequately made aware of. There's a procedure.
Let me
Go
see
ahead.
if I can clarify a little bit here. Should we grant our appeal, does that make the materials proper?
No, it doesn't. And therein is why we have the second part of this. And that's where I think there's all of this confusion, okay? Regardless of how this board rules on the appeal, if staff still believes us to be in violation, the only way in which all of this gets taken care of is through a variance, which is what we've asked for. Now, we have a requirement under the law to exhaust our remedies, and we believe that there was a deficiency in the interpretation of the ordinance. Our remedy is to bring that on appeal. But knowing that the only way this gets fixed is through a variance, the second part of this whole equation, which makes it confusing as to why we're here today, is that we have to have a variance. In order for, if staff maintains that that is a violation, which Mr. Evans has made very clear they do, the only way in which that gets dealt with is through the variance process.
We are well aware of that, but we've been hung up now for over an hour on an appeal process.
That's right.
That we don't understand what you even expect to get as an appeal.
Madam Chair, may I
Yes.
please interject for one
Are
moment?
you sworn in?
I'm not really
She's the attorney.
a
Expect to be.
witness, I'm just gonna let you guys know about the interpretation part that he's asking for, just so that everyone's on the same page. It's your kind of, it's your quasi-judicial function is to interpret the ordinance. I think that's what he's asking for, is for your interpretation. Tim has offered his interpretation of the ordinance and how the town has sees it. Mr. Tarrant is trying to offer his interpretation of the ordinance. You are supposed to interpret the meaning of the parts of the ordinance that might be unclear, apply that ordinance to this particular fact situation, and if necessary, you can correct any mistakes or abuses of discretion that may have been made. That's the duty of interpretation for this court. It's not, it's just, you're seeing if this ordinance is unclear, and if it is unclear, if you believe it is unclear after you've been given all the facts, you can try to interpret that those meanings. That's what he's asking for, correct?
That is, and that's
Okay.
my duty on behalf of my client is to
I
do
just wanted
that.
to make sure everybody,
The facts are the facts, in my opinion.
Right.
Just,
right,
you're shaking your head, Tim.
Well, I'm not going to feel recognized, but I think there's some facts here that are either unknown and need to be said. This is the stuff that I do. You cannot give an appeal to the material types for that fence. 322.2 and 322.1 comes out of the North Carolina Residential Building Code. That is a statute. The appeals for that is to the building code council. Well, actually, the first appeal, if a permit is issued. If it's not issued, then there's other action. But if we issue a permit and he doesn't like the permit that we issue, the appeal for that is actually to the building code council. The first appeal, if it was, bill permit was issued to her, is to me, under the statute. You cannot decide that what materials we use in construction or structure.
And that's what I said in the beginning.
The ordinance simply says that it has to follow the NFIP guidelines.
Right.
The statutory rule under 322 of the North Carolina Residential Building Code says that the building official has the authority to follow this, and in that section, it tells you have to use certain materials in certain locations. In this particular case, this is not a matter of different materials. The construction does not allow for the relief that is required. So what he should be asking for, if the idea is to keep the fence that he wants, is he should be asking for a variance of our floodplain ordinance requirements, is what he should be asking for, and not for the materials. The materials are set forth in the building code, what can be below the floodplain, and how that stuff is built. So I think I understand what he's asking for, but he can't change the method of construction in North Carolina. On this board, he can't do it.
Not with us.
Yeah.
It's not exactly what I'm asking for. That's fine. All we can work from, and the only thing that we've appealed from is what was included in the notices of violation. And I can tell you right now that everything that Mr. Evans just said was nowhere to be seen in the notices of violation, nor does my client have any understanding from the town as to any of those things. Now, regardless of that, and whether or not this is the appropriate forum to even decide that, that is not why we're here. We're literally here to appeal what we received. That's all we can do. And what we received was nothing.
All right, does anybody want to end this or continue or what?
I had a question. You said if we granted the appeal, then you were going to ask for a variance. Well, Mr. Evans said in the beginning that this is a regulatory rule and that you cannot give a variance for a regulatory rule.
I think
Did I understand that
he's
correctly?
asking for an appeal of the interpretation. I'm assuming that he's asking for an appeal of the interpretation of the right-of-way, which would be the regulatory portion, and he can ask for that. I believe. He can clarify it, but I think that's what he's doing.
There's two things. The right-of-way, I am asking for an interpretation of the actual ordinance section itself that pertains to the right-of-way, section 95.
Yeah, that's it.
That is a specific interpretation of the ordinance. Secondly, we are asking for an interpretation of the ordinance as it pertains to the process, the notice of violation and hearing process, which we believe requires Mr. Yaroshevsky to have been alerted specifically as to the violation upon which he has committed, in order for him to then have the opportunity under the town's due process to appeal and be heard as to that violation. And our position has consistently been that that was not provided to him. That does not get to the underlying issue, which is whether or not he is in violation. It merely gets to our argument and our position that the process was not followed as it pertains to the materials. Now, you as a board could completely tell me that you don't agree with anything I just said. You are entitled to that right, and I understand that. And all I'm saying is that our secondary request, which is an alternative request, is a variance. And ultimately, I will be straightforward with you. The variance is probably the cleanest way to make this go away. Because what happens on the process violation is that the town could turn around and renotice us. They could turn around and renotice us. And that starts the whole process over. That doesn't make it go away. As Mr. Evans has rightly stated, we cannot get rid of a violation unless we went and tore down that fence and rebuilt it in accordance with what staff believes to be the proper materials and the proper location. We are merely here following the due process that the town affords us in order to be able to get some idea as to where we are. But ultimately, the variance is probably the cleanest way to go. If you deny our appeal, we move on to the variance. It's a completely different set of standards. If you grant our appeal, we still move on to the variance. That only becomes an issue if you deny our variance. So we have to determine where we are when all the smoke settles.
Do I hear a motion that we vote on the appeals?
Madam Chair, I have a question.
Sure.
I have
Ricky.
we're voting on two different things, right?
You are, and we haven't really presented
We
our
haven't
position
got
on
the
the
variance
variance.
yet. We're
Process?
still on the
No, the process or the materials. We're voting on the appeal.
appeal.
Appeal of process and appeal of,
So
Materials.
it's interpretation as to the 95, section 95, which deals with the street
of right away.
right away, and then
And
as
the
to the
process.
process
So we
on,
have two questions, two parts of that
Yes,
appeal.
but we're only
Are we-
dealing with number one now.
Are we gonna do two of these?
We
Or
have
gonna-
to, we have to do,
Yeah,
it's
okay.
up to him, what
All
we
right.
do with this.
Or do you want to bundle them together both?
no, I'm fine with you to do it however you would prefer as to the
Well,
appeal.
you have stated in the beginning that if we denied the appeal, then you would go to the variance.
We're going to the variance regardless. I mean, we've asked for it, and we have a matter that's not, just so you're aware, I mean, we have not touched on the height at all as part of the appeal, and that was clear in our,
Right.
our
Madam
letters.
Chairman, I would suggest that we conduct a vote
Yes,
on the appeal portion of this argument, that is really two questions, but it's one vote with regard to whether the process or the materials complaint would be acceptable in an appeal format, and get that off the table.
yes.
If I may, just to, and you're welcome to agree with me or not as far as your own process, I think it may be better for the record for you to take each one of those violations and vote on each one of those as to the appeal separately. So
Each
you're
one
not
of the
combining.
violations, I beg your pardon.
Section 95 as to the street right-of-way, and then the section as to the materials. Those are two separate arguments. One is an interpretive argument, one is a procedural argument. I think for purposes of the record, it would make it clear as to the board to vote on each one of those issues separately, as opposed to a motion combining.
What's the position of the board down here?
I can handle them separately either way.
I can too.
Separate.
Separate.
Separate, we need some more voting material. So we'll now hear a motion for the first appeal vote.
Oh, one.
0125, the appeal for interpretation of the encroachment.
Can we mark them both on the same ballot, and mark them one?
I want a ballot each.
All right.
So, first one is 9505?
They're all 95, I'm sorry.
And what's-
Yes, and that, it was 95, but it was appeal number one,
Oh.
which would be the interpretation of the encroachment 9501, is that right, Tim? I'm confused.
I'm confused. I don't know what the appeal
I'm
is.
confused too.
We're all confused.
I'm totally confused.
I don't know why this has got to be separated.
Okay, so
Okay.
materials is the procedure, and then your interpretation is to the right-of-way portion.
Correct, that's what I said.
Okay, so there's two separate votes, right? So the first one will be the materials.
No. No, number
Let's do
one
it the
is
other way, I've already written
encroachment.
it
He
down.
talked about encroachment first.
All right, clarify that you guys are voting for encroachment, right-of-way?
Interpretation of encroachment.
All right,
And that is vote number one.
That's vote number one, and we don't have votes for number two. The board votes unanimously against the appeal for interpretation of 9501.
and that's against supplying a different interpretation other than the
Exactly.
ordinance. Okay, just want to clarify.
We are applying the ordinance as written.
Okay.
Now, what do we do?
Now, the second one is, case number is 0125.
Maybe make it B, maybe make it B, number 2B, or A, B, C,
So I'm putting appeal number two,
appeal 2, okay.
and he's questioning our procedure in the town procedure as to how we have followed through.
Oh, sorry.
No problem. We have unanimous vote against appeal number 2. 4-5. 4-1. Okay. We finished with this part. Moving on. Who wants to be first, Ms. Mattel?
Or variance, correct? We're
Is
now on
this,
variance.
we are now on a variance.
Whatever
If
y'all
he-
want
if he
to
wants,
do.
if he wants to go first, that's fine. I can go. But I pretty much.
This is number 3.
This will be our vote number 3, yes. When it comes to, we'll be for against the variance.
All right. If you look at the survey, I think you can tell that the violations are, are there. The violation is that the fence is too tall for the front yard, and that the fence is actually encroaching into the right-of-way in violation of the ordinance. Not sure, staff, do y'all have anything else other than it's too tall for the front yard setback, and it's in the ordinance? I mean, it's actually in writing. So, and they're provided both they were provided the rules, and the ordinances that went along with that, that would be a violation, I believe, of 95.8080, and of course, the 95.02. And that's the town's position. I mean, also the town's position would be that, that the fence was actually placed there without a permit, and without a site plan.
I have a question, Mr. Evans. Before coming here, I did actually Google, do I need a building permit to build a fence in Holden Beach? The answer and Bing and Google were both, yes, you do. But they both recommended contacting the local building department.
Well,
What would the building department would have said?
If you would have to get a zoning permit pretty much anywhere. You can't issue a building permit before it meets all the state, local, and federal guidelines. We ain't even got to the building permit process yet.
I'm addressing the question, do I need a building permit to put a fence here? If I called you and said, I'm going to build
Oh,
a
yeah.
fence on my property,
We would issue you a building permit depending on how much it costs and the materials, so that we could follow the NFIP for those materials. And there's a reason for that rule but that's why we would issue the building permit. But if we were to see first that in the zoning application, say for this particular permit, because the NFIP is referencing our ordinances, or our ordinance is referencing that, we would have looked at the materials. This is what we would do. Jana would get it, she would look at the materials that were being used, the fence type, because that would have to go with the zoning application, the height of the fence, and the location. So if we look at those three things, and none of those things are going to be in violation of the ordinance, we would simply issue a zoning permit and then enforce those under the zoning permit, saving the property owner the building permit per se, because we can enforce those 322 sections. Now, when he gives us that zoning application, if we come to the conclusion it may be a big fence, or it may be a fence that could be in a CAMA zone or in a floodway, we may issue a permit, or we may issue a card that says no permit required. But that does not relieve them of following the zoning in the town. So there's a process that we never got to that would have determined, you know what I mean, whether he was gonna need a permit or not.
So your advice would be apply for the permit, we'll let you know.
Well, no, my advice is you get a zoning permit. You have to apply for the zoning permit so that you know if you're actually in compliance. You're not gonna build a house and come get a permit. You got to bring us a whole section of documents to show you're actually building on the right lot, you're building inside your setbacks. You got to bring all that and get it approved before you can ever submit a building permit, because you're not gonna go through, would he have gone through the process of putting the fence there? Had he have known he shouldn't be putting it there? Of course he wasn't. You follow what I'm saying? So the process wasn't followed, you know what I mean?
Right.
Which was to get a zoning permit. We ain't even got to the building permit, and building permits are not a purview for the town. Building permits are general statute. 160D 1110 provides the jurisdiction is me and Carrie. You or the commissioners or no one else decides when a permit gets to be issued or when it don't. The statutes are clear about when we're supposed to issue the permits, and a lot of times we have to make our judgment call, especially on the minor things.
Okay,
Yeah.
thank you.
Any questions? Mr. Evans? Gordon? Board members?
All right, so I understand that you've been here a while and you've heard a lot of the same things, so I'm not going to belabor the points. Is my PowerPoint still up there, Madam Clerk? All right, so I'm going to go try to get through. All right, so we're here now on a variance, and when we look at a variance, there's 4 findings that you, as the Board of Adjustment, are required to find in favor of in order to grant the variance, and that vote would need to be a 4/5 vote of the board. And I think it's important for us to just run through these real quick, because
We have copies of them.
I understand. Because I, as the applicant, have to show you, as board members, how we satisfy those. And so unnecessary hardship would result from the strict application of the regulation. The hardship results from conditions that are peculiar to the property, such as location, size, and topography. And I'm just going to paraphrase, as you do have them in front of you. The hardship did not result from actions taken by the applicant or the property owner. The requested variance is consistent with the spirit, purpose, and intent of the regulation. So, again, my client, we clearly have some issues with the fence. I think we will admit that, we know that. We're here to the board to request a variance from the ordinance because there are certain provisions of this fence that do not meet the requirements of the ordinance. Number one, the height of the fence. As Mr. Evans has pointed out to this board, the location of the fence is in what the ordinance classifies as the front yard of the lot. And the requirements of the ordinance are that the fence be limited to 4 feet in height. It is undisputed that the fence, where it's located, is 6 feet in height. That would be 2 feet in excess of the limitation that the ordinance places upon us. What I would say is that all of the pictures tell the story here. This is not a lot that is like majority of the other ones on the island, in that it does have the very unique topographical location and size criteria that number 2 in our findings require that you have when we're analyzing whether or not a hardship exists. What you can see from the pictures and from the surveys is that the road dead ends, the driveway wraps around the house, and the house itself, lots of pictures, actually shows the back, well, what I will call the front yard. looks more like the backyard. I don't know if you can see it up there in color, but the way in which this house is configured so that it fronts the marsh and it fronts the water. It's not configured so that it faces the road or that it faces the little grove of trees or the empty lot across the street. So when one looks at it, and I understand in how the ordinance defines front yard, there is no dispute, I'm not arguing that. But the house itself is configured in such a way as to the front yard by ordinance is actually more like the backyard than a normal house. The area in which the grass is located, the yard is located, most of the time would be in someone's backyard. This is located in the ordinance-defined front yard. We have very clear, unique characteristics to this lot. Not only does the front yard act more like the backyard, but it abuts directly with the aforementioned grove of trees that we've discussed at the end of the right-of-way. For all those reasons, it's our position that we clearly satisfy the hardship definition that's set out in those 4 findings, because we do have some very unique topographical and location characteristics. If my clients are forced to rip out this fence, they clearly would be suffering an unnecessary hardship in that ultimately the location of this fence is in line with and does not seem to harm or injure anyone else's use of the neighboring properties. It doesn't impact the view shed of anyone else. It doesn't abut and obstruct anyone else's use and enjoyment of their property. And that ultimately the spirit of the ordinance itself, which is to keep shorter fences in the front yard, is in order to provide an aesthetically pleasing look. Nobody wants a privacy fence in their front yard, right? It's not in play here because there's nobody across the street. There's a grove of trees. Literally, there's a grove of trees. And there's a marsh. And so allowing Mr. Yarashevsky to keep his height would continue to maintain the spirit and intent of the ordinance. 6 feet is allowed in the back. It's allowed in the backyard. And it's allowed in the backyard because most of the time a backyard is not considered and doesn't have the same type of aesthetic concerns that the front yard would. It doesn't have the obstructive type concerns that the front yard would. And again, because of the characteristics of this property, we don't believe that those issues are in play here the same way they would be in a normal lot or a normal parcel. We've gone through and discussed how Mr. Yarashevsky bought the property in June, and he hired what he believed to be an expert, someone with the type of professional experience that should have been able to know how to construct the fence within the town of Holden Beach. And Mr. Yarashevsky did not construct the fence. He relied upon the expertise of a professional who held himself out as knowing and being familiar with the town's ordinances. As Mr. Evans has laid out for us in very great detail, those ordinances weren't followed. The procedure wasn't followed. If it was followed, we wouldn't be here today. We admit that. But Mr. Yarashevsky can only do so much, and that ultimately these hardships were resulting from those actions of that contractor. The variance here is for zoning. It's to comply with the zone. As Mr. Evans has pointed out, we have other hurdles to get through as it pertains to the building and the building materials. And my client has indicated to me that he is willing to work through those material questions, that in order to comply with the NFIP program, we are aware of the requirements for pass-through in order to be able to maintain and meet that criteria. And we are willing to work with that criteria as it pertains to the building permit. My understanding is that would come secondary after the zoning, which is what we're here for as far as the variance is concerned. I believe I've touched on all 4 of those findings as it pertains specifically to the height. I would say that as to the roads, most of those same things, and the road encroachment, most of those same issues apply. If I can get back to the pictures. Again, this is for instruction purposes only. That white fence, is my understanding, Mr. Yarashevsky, that was there, correct? The white fence, which is actually closer into the road, was there at the time that he bought it. That's been there for, I don't know how long. I didn't check the GIS, but it's been there for some long period of time, years, and has not been deemed a violation, and it is encroaching into the road. Mr. Yarashevsky and I would just assume the fence installer just continued right on down the line with, and we can debate whether or not that was a smart thing, probably not, because that's why we're here today. But again, he has continued that fence, and it's actually behind the pre-existing white fence. That white fence is actually in front of the paved area. That brown privacy board-on-board fence, which is why we're here today, is in front of the unpaved right-of-way. There's no roadbed or pavement there at all, and in fact, you just go right out into the marsh right there. So again, this lot, you can see the fence here. This lot, you can see the marsh and the bulkhead there on the side. If you look at that bottom picture, that whole grove on the left, that's what's in front. That's what's in front of the house. So what we're asking for is for a variance from that encroachment as well as a variance from the height that we believe would be appropriate in this case because of the variance requirements. The variance is there because the ordinance itself is not a one-size-fits-all document. The variance procedure is there in order to provide applicants like Mr. Yarashevsky, who have a very unique situation, a very unique lot that doesn't fit in the nice box that all these other lots do. And I understand that there are streets on the island that also pose their own unique topographical and situational concerns. But overall, the variance process allows this board to look at them on a case-by-case basis and decide in certain situations if the ordinance can be altered in a way in which to accommodate those unique situations. Now, I don't know of any more unique situation than having a house that essentially has the front in the back and the back in the front. Now, whether that makes sense or not to you, it's not really, or to me, it doesn't really matter. It's just the way the truth of this is. This house was built to take advantage of the views that we would all want, which is the marsh and the waterway. And it's posed some serious problems for Mr. Yarashevsky. Going back to those findings real fast again, I asked the board to look at each one of these and to apply each one of these to Mr. Yarashevsky's situation, and to find that this hardship really results in the configuration of that lot, and that ultimately what we're asking for would continue to be consistent with the spirit and purpose of those ordinances themselves. We're not interfering with the road. There's no chance that that fence is going to encroach upon any type of traversable roadway. I believe it was stated by the board that although it could happen, unless someone's driving into the water, it's highly unlikely. And the fence height itself is not impacting the view shed or the aesthetics or obstructing anyone else of his neighbors from the normal use and enjoyment of their property. And ultimately, that's what those ordinances are there for. So even if this board is so gracious to find in favor of a variance, that only handles the zone. And Mr. Yarashevsky understands and knows and represents to the board that he will cooperate fully with the town in order to make sure that he's in compliance with the National Flood Insurance Program and FEMA regulations as to the materials and the pass-through requirements that the town seeks to enforce as to those regulations. So again, I'm available to answer any questions that you may have. We ultimately respectfully request this board to find in favor of each one of these findings and to grant Mr. Yarashevsky the variance that he seeks as to his violations regarding the height of the fence and the encroachment into the right-of-way. I do, again, understand that it would not be appropriate for this board to weigh in on the requirements of the materials. I'm here to answer any questions that you may have.
You were asking us to give a variance on the height of
Yes,
the
ma'am.
fence and the location of the fence. And we're not giving a variance as you requested earlier on the materials.
Well, my understanding as to the materials is that it's part of the National Flood Insurance Program anyway.
We can-
So ultimately, that's not,
I have a
what-
question of
Yes,
Mr. Yarashevsky. The height of your fence, because there is no turnaround at the end of the road, when people turn into your driveway or the driveway, I was down there a couple days ago and I turned into the driveway across the street. Did you do the height of your fence to keep lights from going, car lights, and should people turn around at night?
Partially, yes, ma'am, only because we're at the end of the road. And you don't realize it's dead end until you get to the dead end sign. Primarily, we did that because we had 3 rescue pets, 2 females, 1 male. 2 females are about 60, 65 pounds. The male is larger, he's about 90. We're trying to be responsible pet owners. A 4-foot fence will not cut it. Those 2 females can clear a 4-foot fence. I know this because in Sampson County, I have a 4-foot fence. It's a running start now, and I don't want an issue with another dog, another animal out there, and we have not had any issues. Okay? No one has asked throughout this whole scenario why we put the height and why we use the material. It's primarily to keep our dogs inside and so that we don't have issues with other animals. The white vinyl fences, split, crack, they're ugly, and I just don't think they're sturdy enough for the size dogs that we have. And they're not vicious killers, ma'am, but I don't even want to go down the path. Neighbor behind us on Beale Street, his dog is loose all the time, and I'm trying to avoid potential problems.
Thank you.
Excuse me. Your side yard has a metal 4-foot fence, is that true?
That's 5 foot, aluminum 5 foot.
5 foot.
Yes, sir.
Any other questions?
No.
All right.
Madam Chair, can I
Yes.
make a motion that the board go into executive session? There's a lot of moving parts
We
here.
cannot go into executive session,
Can't?
that is not allowed in our board.
Okay.
It is not allowed because this is a quasi,
Quasi.
yeah, and we can't have a discussion without it being open and publicly, and we're here to look at the facts
Yeah.
as they
Okay.
stand. I hear a motion to vote, or do you have any further questions, or, yes, ma'am, Mary Lou?
No, I thought the attorney was going to speak.
Well, I have something to add.
Okay.
Number one is for the facts that have been presented under the rules, the town does not stipulate to any of those. We don't think that he meets any of that criteria. Because the way the ordinance is written, even in the other areas in the town, everywhere there's not a street on both sides, where there's a street in the front, that is the front yard. To give a variance, you have to find one, you have to find all four. You can't find any of them. And, but clearly, his intention was the issue was put up a 6-foot fence. He told you why. And he never came and got a zoning permit. And now he has a fence that don't comply, a fence that could have been properly installed on the backyard. I mean, the dogs don't go in the backyard. I mean, I don't see where the dogs need to have a fence to protect them in the front yard when you could have put a 6-foot fence in the backyard. But you chose to put the 6-foot fence in the front yard. Also, that wrought iron fence is actually in the front yard. The metal one's actually, that is considered the front yard, that's the front of that house. The side yard would be on the side, which is actually got a bulkhead going down the side of it there. But I think that in the staff's position is that we do not stipulate to any of the criteria for a variance. It'll be up to y'all to decide if he meets any of those criteria.
If I may, I would object to the staff's opinion as to whether or not we meet the criteria. I don't believe that's why we're here. I don't think that's the purpose of the variance. I think it's for the board, for you folks to determine whether or not we meet that criteria. Number one, to staff's position about the backyard, these pictures are pretty clear. The backyard is the driveway. There's the way in which, and part of the confusion with this is where the driveway comes off of the road down the side of the house and wraps around to the backyard and goes underneath the house. So essentially, you've got a backyard that has the driveway. The front yard does not have the driveway. It hugs the side of the house and goes around the house. So what staff's saying is to put the fence in the backyard and block the driveway, you would need some sort of gate in order to be able to keep your dogs in that backyard area, which doesn't seem practical to us. Regardless, Mr. Yarashevsky has indicated to me, and I do want to make sure that I've communicated this to the board, that we've requested a variance from the 4-foot requirement to keep the 6 feet that we have. Mr. Yarashevsky believes that he could work with the 5 feet he would be willing to cut it down a foot in order to be able to make sure that he's got that additional foot to keep the dogs in. I think that, as he's explained, the 4 feet is just too low, but he would take it even with the wrought iron type structure fence that's on the backside in order to make sure that height is even all the way around to 5 feet. If the board would so consider that, we would like me to communicate that to you.
Can we pull up the GIS map that we have? Staff, when staff doesn't stipulate, we did that so that we wouldn't have to make any more commentary, but since that seems to be an issue.
I'm going to object on the record to anything that he says as to interpreting the actual variance.
Well, hold on a second. Hold on a second. When it comes to interpreting the zoning code in the town of Holden Beach, I am the expert. And you know who is not the expert in this room when it comes to interpreting the codes? You're supposed to be an expert if you're going to give evidence.
Mr. Evans, are you the Board of Adjustment? Are you the Board of Adjustment?
No, sir, I'm not the Board of Adjustments, but
then I think that they are tasked with this.
One at a time, please.
Okay,
Sam?
all right. the property owner's attorney, has stated that he has unique qualities about his lot. There are plenty of lots on this island that meet those similar requirements. So we don't stipulate to that. As a matter of fact, there's a house right behind it right there. The other thing is that he's got plenty of correspondence. He says he has. Staff never had an opportunity to hear some of these things like headlights and dogs. We didn't hear any of this till today. And that's okay, it can be part of the record, but I would like to make it, we had no opportunity to evaluate that. Not that I think that it has any criteria, but we haven't heard that. What we have heard, and I would like to ask the property owner this, did you ever at any point in time tell me you were going to put a pool in the front yard or behind that fence?
I had mentioned we looked at the option of putting a pool on the property, yes. If you choose, I think you should make it clear, a variance for a fence is not a variance for a pool in the front yard. A variance is just for the part that they're asking a variance for. Also, I want you to keep in mind, the fence is in the right-of-way. You can't give a variance on that portion of the fence that's in the right-of-way. He's talking about cutting the fence down. I think that's wonderful if he brings it down to requirements of the ordinance. But the fence cannot stay in the right-of-way. Even if you give that variance, I'm not sure how we issue the permit. So we don't stipulate to any of the 4 findings for, in other words, we don't believe he meets it.
For the record, I have a requirement to object to this.
Requirement.
I have a requirement to object to this. I've been in many variance hearings, and I've never heard staff so strenuously argue against a variance. It is not proper, period.
Mr. Collins, and we interpret what he is saying as giving us what the variance is saying, exactly what it's saying.
And Madam Chair,
To this issue.
Madam Chair, you're entitled to that, but I will say this. The words that came out of Mr. Evans' mouth were more than this is the ordinance, and I'm
He said
stating
that
it.
they, as the board, that they do not stipulate to your arguments in number 4.
And that, look, the record shall reflect
Do I hear
for
a motion
appeal
that we
that I
strike
object.
that from the facts? Do I hear a motion that we not have part of the record what Mr. Evans said regarding the 4 cases that they presented in favor of this case? I need somebody to make a decision. I'm not the only decision maker here.
I have one question for agenda item number 4. There's a bit of a 90-degree angle on that fence. Is that accurate? And have you taken a lawn chair and sat in the neighbor's driveway to see if you could see the waterway?
They can see the waterway. Which property are you talking
The
about?
one right behind you,
The one
the
beside
same
you.
side of the street. Right behind you.
119.
You can't. Prior to the fence, you could.
119?
Maybe, I don't know.
Across the street or
No,
next door?
same side of the street.
Same side of the street?
Yeah.
Yeah. They do not have a problem with the fence. I can call, that's Don Daniels and his wife. I can call Don and ask him if you like. It does not obstruct their view at all.
Okay.
Would you like me to call?
No,
Yeah, they received notice of the hearing,
Okay.
just for the record to reflect that they
You have
were.
no problem with leaving it in the record then?
We-
I have a problem with
I move we
leaving
leave it in the record.
I move we leave it in, yeah.
All in favor of leaving what Tim said in the record, say aye.
Aye.
Okay, stays in the record. Do I hear a motion that we call this to vote?
so moved.
Second,
I second.
would you please read your charges as to the questions that you have to answer? And remember that we cannot give a variance on the right of way. Okay. Yes. it's a unanimous vote against granting the variance.
Thank you for your time.
Moving on to the next one. Moving on to the next item on the agenda. Any old business that we need to bring up? Any new business?
I have none.
Do I hear my motion to adjourn?
We adjourn.
So second.
Second, okay. All in favor of adjournment?
Aye.